Good afternoon. On the 20th of September 2023, you're joining an information event today hosted by the Care Advice Line, and our host today is Bill, looking at wills and estates. I'm going to hand straight over to you, Bill. Thank you very much.
Thank you very much, Carrie. Good afternoon, everybody. I hope you're all keeping reasonably dry in these fantastic, somebody said about an Indian summer, more like a monsoon, isn't it, really? Then But thank you, Carrie, once again for asking us to host this session. I've almost lost count now of the number of sessions that we've done on subjects various. I have to keep reminding myself which issue we're dealing with. And today we're looking at managing wills and estates. And as I understand, this is in direct kind of response to requests from carers in Gloucestershire who are looking for some help and assistance on the subject. I say this every time, but obviously within an hour, we can only cover these issues in broad terms, but hopefully enough to give you some information to send you on your way. As Carrie said, if you've got any specific questions, our preference is to leave them till the end so that we're not on the recorded session in case it's something that you want to ask about your personal situation. But if it's a more generic question or a general point, or you've misunderstood something, by all means, sort of put your hand up as we're going through and we'll try to deal with it. So as the name implies, we've split this session into two sections. The first one is managing wills, kind of really a quick guide to all the things you need to be aware of, be thinking of, be mindful and watch for when it comes to establishing wills, particularly in a carer context. And then the second section that we're going to look at is the issue of estates, so sort of post-death, if you like, what happens, and again, what issues we need to be aware of. Just before we start, and I know this isn't part of our session today, but can I just remind everybody, if you don't know already, about just the importance of having lasting powers of attorney as a kind of prelude to wills. I think there's a general perception in the UK that we're all aware of the importance of having a will, but sometimes we miss the importance of having a lasting power of attorney. So if this is something you've already dealt with, I apologise, but just in case you haven't, just a couple of quick points on it. This is the only legal way to arrange to provide authority for you to be able to act on somebody else's behalf. So if you are a carer and you are looking to be able to act on that person's behalf in matters of financial affairs, for example, or indeed care, just to remind you that you really do have to get a power of attorney set up. And I don't really suggest that this is only something to think about when you're older. If you have any assets and you're over 18, you should have a lasting power of attorney, particularly for the property and affairs part, which is the money bit. Maybe slightly less urgent is for health and welfare. And that would deal with things like an admission to a care home, life-sustaining decisions about your health, all that sort of thing. And of course, the big difference now is that if you do have lasting power of attorney, they must be registered with the Court of Protection before you can use them. So if you don't have them in place and capacity is lost, then I'm afraid you are doomed to go down the route of applying for a deputyship, which is both intrusive, unpleasant, extremely expensive, and takes forever. So I can't stress the importance before you do your will of making sure the lasting power of attorney is in place. Right, that's it. Just a very quick recap. Okay. I'm sure you all know this, but what is the purpose of a will? It is simply to set out in writing your wishes as to what will happen to your asset on death. Which, as I mentioned there, what happens if you don't have a power of attorney, just as an incentive to remind ourselves of the importance of a will, is to consider what happens if you don't have a will on death. And basically your estate is distributed under the recently reformed intestacy rules. Now that also applies if you write a will that for any reason is invalid. I do come across a surprising number of wills that have been executed and established in good faith. but then when the time's come to use it, there's been something about the document that makes it invalid. That could be signatures, the wording, any number of things. But the same thing happens if your will is invalid or doesn't exist, then you will be dealt with, your estate will be dealt with under the intestacy rules. And just to give you a quick reminder of what they are, a quick update, only direct family can inherit from your estate under intestacy. So unmarried partners, friends, charities will not, under any circumstances, be included. Basically, the way the court deals with your affairs is that if you're married, your spouse or your civil partner will receive all of your personal possessions and the first £322,000 of your estate, together with half of any balance. And the balance of the rest of it will then go to your children, and it goes through a sequence of children, grandchildren, great-grandchildren. So the position is that you have no control, you have no say in where your money goes to. It simply goes through that sequence, and that's all reasonably okay until you get into the issues of multiple marriages, divorces, stepchildren, adopted children, all the other things that can make that process extremely complicated and expensive and time consuming. So wherever possible, we must make sure that we've got a will, if that's at all doable. So what do we need to have in order for a will to be legal and valid? Well, three things really. One is you've got to be over 18 when you write it. Secondly, you must make it voluntarily. In other words, not with somebody trying to apply pressures or encouragements in a particular direction. And probably the most contentious question is that you must be of sound mind. And that brings in to the equation this question of capacity. But the same with power of attorney. One of the biggest problems is people wait until they have become, to a degree, infirm before they take action. What you need to remember is that the measure of intestacy is different for different tasks. So your capacity to write a will is not necessarily the same as your capacity to appoint an attorney or to make any other decision. People who are unwell tend to have good days and bad days. So I would always say that you might be able to find a good day upon which a will could legitimately and legally be written. The fact is that the day after, that person may be less capable to take that same action. So you do have to take care. The process is the important thing to bear in mind, in that the will itself must be in writing. There currently isn't an arrangement to have a verbal will. It must be signed in the presence of two witnesses who are both over 18. Now, strictly speaking, the witnesses are merely signing to say, I watched you put your name to this document. They're not really saying whether the person had capacity to make that decision. But obviously, it's very difficult if you ask your next door neighbour to sign a document and it's quite clear that you are either acting under duress or that you're not really capable. They would normally raise the question and say, are we sure about this? But in writing and witnessed by two people over 18 in your presence, and normally the actual wording of the will says, you know, I watched Mr. Jones sign his name above, and then you sign to confirm that that's been done. There is no need to register this with anybody. There is no need to send it to a solicitor. There's no need to send it to anybody. That document can be written, put in the drawer, and will only come into play, obviously, at the point of death. Now, in terms of who can actually help you write the will, well, there are three ways, really. The first and most common one is a solicitor. I have to be careful here. The worst wills I ever come across have always been written by a solicitor. And I think it's just because, generally speaking, there is a risk that they don't take full account of a person's situation. We'll come on to this as we progress today. Or they don't listen, or they just don't consider the things that might happen to us during life. As I say, we'll come on to those in a moment. Your other option would be go to a will writer who is not a solicitor and a lawyer in the normal sense of the word, but has been trained in the process of writing wills. There are plenty of them about. Usually a will writer is considerably cheaper than a solicitor. Normally he will come out and see you at home, which solicitors tend not to. It tends to be more you going into the office. The third option, it's just worth remembering, is you can also write the will yourself. If you walk into WH Smith or the post office, you will find in the corner a standard will writing pack with all the instructions and guidance that you need. I don't particularly recommend them unless it is absolutely the simplest form of will. But it is perfectly possible to do it yourself. And as I say, those packs are available. Now, our timing couldn't be better, really, in that next month, October, is Free Wills Month. It comes around every year. You may be aware of it, but it's basically a coming together, really, of a lot of the major charities and local solicitors who are prepared to write wills for free during the course of October. Now, the idea is, I don't quite know how the mechanics works, but I assume that the solicitors do it as a gesture of goodwill to help out the charities. The charities do it in the hope, but not the insistence that you might include them in your will. It's a difficult one, really. If you take up, I don't know, British Legion, for example, they may be doing this, and you take them up on their offer, it's quite difficult not to at least leave them £100 in your will just for the trouble. But it's not an absolutely compulsory thing. What I would say is that Free Wills Month really is for simple wills. It's not fair or reasonable to expect a lawyer to prepare you a complex will, or if your estate is complex, under the free arrangements. And it's not good for you, because I think there's a tendency that it might be perhaps one of the more junior members of the practice who gets the job of seeing people who want a free will, rather than perhaps the more experienced partners. So it's handy to know, but it's not a fix-all for everybody. So just take a little care when you're choosing how you're going to have your will prepared. Okay. Next bit to consider really is what should be in the will. Well, there's a fairly simple set of issues to be addressed. First and most important is it must revoke your previous will. Otherwise, you'll have families in the difficult situation of having two wills. So the first one will always revoke the previous one, and ideally that should be destroyed once the new one is in place. Second thing it will do is will appoint your executors, which is just a fancy legal term for the person who you choose to administer your will and deal with your estate. So that can be family, friends, relatives, neighbours. You may generally find that your solicitor might encourage you to include him or his practice as one of your executors, which is fine, and it can be very helpful to have a professional on board to deal with the process. Just a word of caution, that is also carte blanche for them to issue significant invoices when it comes to the application for probate. They may not make that entirely clear at the start, but my general preference is if at all possible, don't appoint a solicitor as one of your executors. If you need professional legal help, go and get it at the time, but don't have them kind of automatically in this position of executor. And when we come to the issue of estate management later, then we'll perhaps go into that in a little bit more detail. The third thing that your will should detail is any specific requests that you have. This is where you want to leave a particular item to a particular person. So that could be your gold ring to your granddaughter, £200 to the church, a tea caddy that you'd like to leave to your favourite niece. It could be anything that's specific. Usually relatively smaller amounts, generally speaking. Not necessarily in terms of value, but a specific item, a painting, something like that. And then the next bit is to have what's broadly called a residual clause. In other words, having made those individual bequests, and there could be several of them, you know, £50 to each of your grandchildren or great-grandchildren. The next clause would say, the balance of my estate, whatever that may be, I leave to, and again, that's the point at which you would specify. So typically that would say, I leave the residue of my estate to my 3 children equally. That would be a typical, so it's not a specific amount. It's not, you know, A gets this item. It's a catch-all clause that covers everything else that's left after you've made the individual gifts that you want to make. And you might leave that then to a group of people individually or in proportions, whatever you wish. Now, it's always good, and I do sadly see this often missing in wills. It's always good then to have a what-if clause. And the what-if clause is to deal with what if one of those beneficiaries should predecease you. So does the money get divided between the other people equally? Or does that person's share pass on to their children? So it's good to have a what-if clause that covers eventualities, because that's where wills can start to get unravelled if the person that you've left the money to is either no longer here. So good just to have an extra measure. And then the final thing that you might expect to see would be details about, for example, funeral wishes. Do you want to be buried, cremated? And if so, any details that you might want to add at that point. So those really are the main elements that you'd expect to see in a typical will. I've seen thousands of wills over my career, and I don't think I've ever seen 2 the same. So you must remember that everybody writes these things in a different way, different words. There's no preset template for this. What I do find is many solicitors write them in language that are extremely difficult to understand. They go on for pages and pages, and they present them to you and say, is this what you were thinking? And the truth is, you wouldn't really have a clue whether it did or it didn't. So I'm a big fan of keeping it simple, keeping it straightforward, keeping the language as simple as possible. And that kind of leads me on to this, what I think is an important section of things to avoid, pitfalls that wills can present and items to both think about and decide whether you think that's a good idea. So I've covered the first one. Keep it as short as possible, keep it as simple as possible. One thing I'm a particular fan of is the concept of a letter of wishes. This is a document that sits alongside your will. It doesn't have to be witnessed. It isn't legally part of your will. And technically, it isn't binding either. But what it does do is provide you with an opportunity to write down in your own words the kind of message that you would like to give to your executors. For example, details of the funeral. Quite often, people don't find the will until after the funeral has taken place, particularly if it's an elderly relative who they may not know where the documents are. So by the time they've gone through the documents in the house and the various places it could be, sometimes a funeral's come and gone, and only then do they find out, oh, actually, Uncle Jack wanted to be buried rather than cremated, which is obviously a difficult situation to find yourself in. The thing about this document is that you can change it anytime you like. So if you change your mind, if you decide that you'd like to leave your organs for donation or whatever it might be, you can add this into this letter of wishes without having to go back to your solicitor or your will writer, and therefore without incurring any cost to make any changes that you want. And you can say as much as you wish. Now, as I say, legally it's not binding, but I have yet to meet a beneficiary who's dared to go against the express wishes of somebody in their letter of wishes, because it just goes against the grain for them to think, well, if this is what Grandad said, but I'm going to ignore that and do something completely different. So you've got to be careful about what goes in the letter of wishes. As I say, on the basis that it's not legally binding, but you can give some clear direction and some clear instruction of what you would like to happen. And that might be things like, you know, I'm leaving my money to my son, and I really want him to use some of that money to help, I don't know, I'm trying to think of an example, help my granddaughter pursue her career and her interest in music, for example, if she only happens to be 10 or 11 years of age. I mention that because it's one I saw quite recently. The granddaughter had a clear skill and attribute for music, and Grandad wanted to try and encourage his son to encourage her with his money from his estate to pursue that career. Nothing you can write down too formally in a will, but by using the letter of wishes, he was able to express that desire, that wish, if you like. The other thing I think is useful is not to name, wherever possible, specific people. This is particularly true for grandchildren and great-grandchildren. So if you had a wish, for example, to leave 25% of your estate to your grandchildren or your great-grandchildren, obviously every time another one comes along, you have to go back and rewrite the will if you've named them individually. So it can often be quite sensible to simply include them as a category, a class of beneficiary is the technical phrase. So you would decide what proportion of your estate you want to leave, and then say to be distributed equally between all my grandchildren or all my great-grandchildren who are alive at the time of my death. So that will avoid you having to go back and rewrite every time there's another birth. On the flip side of that, if there are close family that you are going to exclude from your will, I think it's very sensible to explain why. Now, that might be in your letter of wishes, but it might also be in your will. Let me give you an example. I had a chap contact me about 18 months ago. He was relatively recently married, in the sense that he and his wife had been together for maybe 15 years, even though they were in their 70s. So she had a daughter from a previous marriage, and they had no children together. And his wife and her daughter had fallen out many years ago, and consequently, she didn't want to leave her any money in her will. In fact, she even didn't want her daughter to be told that she was seriously ill, in fact, terminally ill. When the daughter found out that her mother had passed away, she immediately made a claim against the estate for 50% of the value. And her reason for this was, well, without wishing to put too fine a point on it, that she felt she'd been abused as a child. And this poor gentleman, who knew nothing about this, hadn't really got into too much detail about why his wife had an issue with the daughter, but went to see a solicitor who, well, the upshot was, charged him £10,000 in fees the bill ran up to in trying to deal with this challenge, and ultimately recommended that he pay £15,000 as a settlement to bring the matter to an end. Which he did. So the point is, it cost £25,000 to deal with the daughter who had simply popped up after 30 odd years and made a claim. And the argument was it simply would cost too much money to go to court to argue about this. So I would always recommend that you write that down. It's relatively easy. If you divorce, then your wife or your husband is automatically excluded from your will. In fact, if you've got a will at the time of marriage, it becomes null and void. But where it's closer members of family, that can be much more difficult. So always a good idea to write down, I am not including my daughter in this estate because 20 years ago we had a fallout, she borrowed some money, whatever it might be. You don't have to go into massive detail, but you're merely giving the court some clear direction as to why you arrived at this decision. This particular lady was being especially smart, I guess, by not claiming that she had an entitlement to the estate, but actually suggesting that she had a claim against the estate for past wrongs. A little bit more difficult to deal with, but again, that clause would have helped the court to see that there were issues afoot that perhaps might be prompting the action she was taking. So if you're going to exclude somebody, worth a note to explain why. Another thing to watch out for, I mentioned before about leaving percentages to classes of beneficiaries. I would very much encourage that you do use percentages rather than fixed amounts. The simple reason for that is you might write your will and leave £25,000 to somebody, and at the time it might be, I don't know, 10% of your total estate. 15 years later, if you've been through a care process or had to spend money to support your needs in later life, suddenly that £25,000 might be 90% of your estate. And if you haven't changed it, or you've left the figure as a fixed amount, then it clearly will distort your wishes when it comes to the ultimate settlement. So far better to use percentages, 10, 15, 20%, and then whatever happens to your estate, whether it gets depleted through care or you win the lottery, the proportions will still apply. Again, without the need to having to change your will. Now, probably the biggest pitfall that I would raise about your will is the issue of what I would term wealth concentration. And by that, I mean the typical arrangement between a husband and wife or civil partnership is that they each leave everything to each other and thereafter to the children. That's the most typical will that I would come across, commonly referred to as a mirror will because they both reflect the same thing. Now, as a carer or in a caring context, that can be hugely problematical. For example, if you have a house worth £200,000, technically speaking, that might be owned half each by the two owners, £100,000 each. If the husband dies and leaves everything to his wife, then she has £200,000. She owns the full value of the property. But if anything happens to her in the future, for example, a care need, then the local authority will be able to take account or expect her to use the full value of the property to support her care. So that's what I mean by a concentration of wealth in the hands of the survivor. It could arguably be better if the husband left his half of the house to somebody other than his wife, so that then he dies, his half goes to wherever, and we'll talk about that in a moment. So if anything happens that requires his wife to then need care, she only has £100,000 for the property, not 200. Now, some people find that a little bit difficult because it effectively means disinherit your spouse or partner. But if you leave that money to the right person or the right arrangement, they can effectively hold it on their behalf and use that money or use the interest it generates to help out. And I'll explain that in a little bit more detail. If that is something you want to do, there is one step that has to be taken first, and that is to do with the way in which property in this country is owned. There are two ways a property can be owned. First one is jointly, which actually means that you both own all of it. And the rules are that any asset which you own jointly, whether it's a property or a bank account, can only pass to the other owner on your death, regardless of what your will says. So I do see people who leave their share of a property to somebody other than the other owner and forget to check how their property is owned. And if it's owned jointly, then their will doesn't apply. What you have to do is to change the ownership to something called tenants in common, which is exactly the same, except that you each own a clear half. And because you own half, you can leave it to whoever you want to. It is not owned jointly. And that sounds quite technical. It isn't. Although the way in which you achieve that sounds a little brutal. You have to sever a joint tenancy in favour of a tenants in common. It's one sheet of paper. Solicitor will do it for you in no time at all. It's registered with the land registry and will appear in the online details of the house. If you're not sure how your house is owned, you can actually go and search the land registry and find out. As you can imagine, they don't make it simple. You'd like to see that there's a sort of header at the top of your property that says this house is owned tenants in common or jointly. It doesn't, I'm afraid. There's some very convoluted wording in the deed that will tell you whether it's tenants in common or not. But if you have any desire to leave your share of a property to somebody other than the joint owner, you have to get tenants in common in place. Hopefully a solicitor would advise you to do that when setting up your will, but just make sure that that's done. I've had a person contact us only this week where they thought that they had done that. Well, they had done it. They'd severed the tenancy on the house they were in and wrote their wills accordingly and then moved. Unfortunately, the solicitor who acted on the new house purchase didn't ask them whether they wanted it to be tenants in common or joint and just did it as joint. So quite by accident, their wishes were overridden by what the lawyer did because he didn't bother to ask the question. So in turn, that kind of leads on to the concept really of trust. If you don't want to leave your half of the property to your spouse because you want to avoid this concentration of wealth, you could just leave it to the children, to a friend, to a relative, whoever. The trouble is, it then becomes theirs. They're free to do with it as they wish, and that can in itself create problems. So you might be sort of jumping out of the frying pan into the fire. So the common solution to that is to leave your respective share of property in trust, which again is one of those phrases that creates a degree of confusion and assumed complexity. A trust is a very simple thing. It's just a legal mechanism for something to be held on behalf of other people. So you could set up your family trust, you'll use your surname, the Jones Family Trust, you leave your half of the property to it. So it's not an individual, it's not your partner, but it will have what's called a trust deed. And in there you will say, I want to appoint my wife and my 3 children as the trustees. They're the people who will run this trust, who will make sure it does all the things I want it to do. And then what you'll say is, I would like it to benefit, and you would list all the people who you might want to potentially, and that's the key word, potentially receive benefit from it. So you would include your spouse or your husband or your wife and your grandchildren and everybody else that matters. So if you apply that in a typical context of care, take my example of husband and wife, husband dies, leaves his half of the house to trust rather than to his wife. 5 years later, his wife goes into care. Only her share of the house will be assessed as being capital for care. His half is now held in a trust. But the trustees have been told the priority is to make sure mum's looked after during her lifetime. So if there's any top-up fees to pay at the care home, or if she needs any help to supplement what the local authority might pay, the trust can step in. But the significant thing is that the capital in that account is not hers. She can't be assessed on it. So what you've done is you protected it and ring-fenced it, but still made it available to her, which obviously, or in most cases, would be the original wish. So using trusts in that way to avoid this concentration of wealth, particularly in a context of a future care need that might have an entitlement to local authority support, can be really helpful. Now, it might be depending on the value of the property, that in that example I've given, the wife the house might be worth £600,000 and her half is 300,000. She'd probably never make a claim on the local authority, in which case it would matter less. But what I am seeing is a greater concern amongst families that if they leave their assets to the children, we'll start there, that there is a real risk at some point that that person may in themselves get divorced, set up a business that might get into difficulty. The divorce is the most common concern, and of course that could mean that half of the capital that you left to your son or your daughter may suddenly be in the hands of their spouse during a divorce process. And trust can help you avoid that. But the way that works is you leave your estate to a trust, and the trust makes loans to these people, would make a loan to your son or daughter. And then if they ever get divorced 5 years down the line and their spouse is claiming half of the money, they can stand up and say, well, I can't give it to you because we still owe this capital back to the family trust. So it's a great way to protect family wealth against, well, I guess just the things that happen in life: divorce, the death of the person, a business failure, any number of things. It doesn't create any added problems. It just gives you a bit more flexibility. Now, we're actually doing a session on parent carers, I think in November. Harry will tell me if that's right, where we're going to look at this specifically as a way of making sure that people who have children who might have care needs, they're worried that they're coming to the point where there may be fewer years ahead than behind, and they want to make sure that on their death, those children will be provided for and not find themselves inheriting properties and cash that would make them self-funding when it comes to their care needs. So that's maybe just a taster into that session. So if that's something that is relevant to you or you think would be interesting, it might be worth coming back when we look at that in a bit more detail in November. So having talked about who can write a will, where you can get one written, what sorts of things it should contain, issues to watch out for, just a couple of other points. Keep it safe once you've written it. Make sure it's readily available, and most importantly, tell the family where it is. Even if it's just, it's in the top drawer of the bureau along with my other papers. And I would encourage people to tell their family what's in it in advance so that they know and they understand why you did this, because it might help them to sort of make sure that everything's as it should be. Final thing I would say is make sure you review it regularly, especially after life events, deaths, house moves, marriages within the family, to make sure that the wording of your will still stands up. I've used this story before, but it's just so good at demonstrating the point. This was a chap I knew who lived in, if any of you know it, Dartmouth in Devon. He had a fantastic riverside property, which at the time was worth in excess of £1 million. His two children, son and daughter, his son lived in Edinburgh and he didn't particularly like him and he didn't get on terribly well. His daughter lived in London and she was the apple of his eye. So in his will, he'd left his house to his daughter and his cash, which was about 20,000, if I remember rightly, to his son. And that was it. But because they both lived away, he'd appointed his friend and neighbour as his attorney. So if anything happened to him whereby he lost capacity, he had somebody local who could help out. Anyway, the chap had a fairly major stroke, which left him completely incapacitated. So the attorney, the neighbour, stepped in to deal with everything as necessary. And he had the good sense to ask the chap's solicitor, could he have a copy of the gentleman's will, just so that he was aware of what was going to happen. And the solicitor quite arrogantly refused and said, no, you're his attorney, which means you deal with issues during his lifetime, and the will is something that applies on death. So no, I'm not going to give it to you. So the attorney just shrugged and said, fair enough, it's up to you. So proceeded to do what he obviously had to do, which was to sell the house to fund the gentleman's care need, completely oblivious to the provisions of his will. Because of where the property was, it sold within days for the full asking price. And sadly, the gentleman died 6 weeks later. So the will that said I leave my house to my daughter and my cash to my son meant that the daughter who he doted on received absolutely zero, and the son who he didn't like received £1 million plus the balance of the cash that he had on deposit, all because the will was badly written in the first place, and the solicitor who wrote it refused on a matter of principle to hand a copy to the attorney who was trying to deal with the affairs of the gentleman. So I only mention that as it's not common, it doesn't happen all the time, obviously, but it just illustrates the importance of getting kind of these things right. And the final thing I would say, which kind of follows on from that, is it's worth just sitting down for 10 minutes and actually writing out a list of your assets. What would your estate be worth? What are the liabilities? It's a session we've done before when we look at inheritance tax and whether there's ways that you might mitigate it. But it's a good idea to have an idea of just how much would this be. And then when you're working out your percentages and how you want to distribute it, you can kind of see what that actually means in money, particularly if you're using the percentage approach, which I mentioned. So there's lots to think about, lots to do, but that kind of covers the bigger section of today, which is to deal with the will. So for the last 10 minutes before we go to questions, I just wanted to move on to what happens sort of after death, really. It's not a lot simpler, but I've touched on a number of these points already, so I'll just take you through the key items. So as we've said, the power of attorney appointment that you may have made, key thing to remember is that on death, that ceases to have any validity. It is a lifetime appointment. And immediately at the moment of death, your executors take over, who are the people named in the will. Now, probably in 75% of cases, those are exactly the same people, but they are acting in separate capacities. So I do quite often get families to say, well, I was dealing with the bank for Dad's affairs as his attorney, but they won't talk to me now that he's died. And that's just because the capacity in which you're acting has changed, and you have to go back through the process of authorization and validation. And the way in which that takes place is through what's called a grant of probate. If you think about it, you may walk into your bank with Dad's will, appointing you as his executor and as his sole beneficiary, and a copy of his death certificate, expecting them to say, fair enough, that's great, walk this way and we'll hand over the check for the £200,000 that was in his bank account. The problem that the bank has is that they have no idea if that will is valid, if it was superseded. But of course, what they do know is if they pay money out incorrectly, it'll be on their heads when the correct person emerges 6 weeks later to say, oh, and actually Dad changed his will and I'm the executor and I'm the beneficiary. So the way in which the process works is to send you off through the court to get the will validated. That's only part of the reason. The bigger reason is it gives the Inland Revenue chance to check if there's any tax to pay. So it's a tax collection mechanism. So what happens is you submit your details. HMRC will look at it to see if there's any tax payable. If there is, they will expect it to be paid before they issue a grant of probate, which in itself can be a problem because it means families have to raise funds from the banks to pay the tax bill before they get the grant of probate, which gives them access to the money. So it's a bit of an awkward process. And then once the grant of probate has been issued, the executors are free to go and collect the money together and distribute it in accordance with the wishes set out in the will. Now, there are some occasions when a grant of probate won't be needed. Basically, when the assets are of a small value, there isn't actually a specific amount. The amount will be determined by the financial institution. I saw a payment made by NatWest Bank to a family where the estate or the account they held was £30,000. They didn't require probate in order to release that money. And of course, that might mean you go to the next organisation where there's 100,000 and they do. But if 30,000 was the extent of it, then you may, in the odd situation, not require probate. I'm not going to spend any time on inheritance tax because I think we dealt with that on previous sessions. I'm conscious of time, but if anybody has any questions, I'm happy to deal with it. On this issue of applying for probate, the rules are very clear in that there are only two people who can apply for this grant of probate. The first one is a solicitor. And I make no apologies for suggesting that I think that's a bit of a stitch up amongst the legal profession. It's a great way for solicitors to earn money. I think the Law Society's latest figure is they advise a fee of 1.5% of the estate value plus VAT and disbursement. So if you've got a £500,000 estate, then you'd be looking at a bill of £7,500 plus 20%, certainly £10,000. Now, the only other person that can make an application for probate is the executor, who doesn't have to be professional. So my advice would always be, going back to the will issue, do not appoint a solicitor as the executor and leave the family with the choice of whether they think they can do it themselves or whether they might need some help. There's a big difference between getting a lawyer to help you with the paperwork than actually asking him to do it. And you can go to a financial advisor who might have arranged mum or dad's finances and might know all the figures that you need for your grant of probate. But it can be a costly and expensive process. Typically at the moment, it's taking between 3 and 9 months to get probate through. So it's not a quick process. You've got to be patient. But you do have to act quickly if there's inheritance tax to pay, because it has to be paid within 6 months of the date of death. So it all really depends on how complex the estate is, how valuable it is, what amount of money we're talking about, is there inheritance tax to pay. So generally speaking, estates of less than 325,000, which mean there won't be an IHT liability, that might consist of a house or a house and cash or a few accounts or a few shares. Generally speaking, that's not going to fall into the contentious, difficult category, and would generally be something that a family could do themselves if they've got the time and inclination, or with a little bit of help. The other choice is you go and appoint a solicitor to do it, and he will take over the whole process, so it's much less intrusive, much less demanding on you. But bear in mind, the solicitor knows nothing about your deceased relatives' affairs, so they will pepper you with questions. And I do find families thinking, well, by the time I've answered all the solicitor's questions, I could have actually filled in the forms myself. But it depends, some people find the forms horrendously complicated. Others, if you filled in an attendance allowance form, then, or a power of attorney form, then it's not that difficult. There's one final thing I'm going to mention before we go to questions, which is a slightly odd concept, but it's the idea that once an estate has been settled, a grant of probate has been given, all the processes have been gone through, it is possible for families to vary the will, to go back and retrospectively change it. And you may think, well, why on earth would I want to do that? All sorts of reasons, really. One of the people who is going to inherit from dad's estate might already be extremely wealthy in their own right, have built up a successful business, and have their own inheritance tax issues, which will be compounded by them receiving £100,000 from dad's estate, for example. Now, if that person receives the money and then gives it away, which would be the obvious thing to do, then they have to live for 7 years for this IHT clock to run through. So the idea of changing somebody's will is to legally bypass yourself and say, no, I do not want to receive this money. I want it to go to my children. And there is a formal process. It's called a deed of variation, where you go back and you effectively rewrite Dad's will 30 seconds before his death and change the people who will receive the money. Now, all the beneficiaries who are affected by this have to agree, obviously. You can't simply go and say, I don't want young Johnny to receive this money. But that is an example of why people use it. I've come across lots of families where, unknowns to Grandad, one of the grandchildren that he's left money to has become an addict of, it could be drugs, it could be alcohol, it could be anything, got himself into bad ways. The last thing the family want to do is for him to receive capital that he'll then waste or worse still, do harm to himself. So there are lots of circumstances in which a deed of variation can be a useful mechanism to go back and change things if it's in the best interests of the people involved. And you have up to 2 years after the date of death to make such an amendment once you've got the grant of probate in place. The one area that it is a bit more problematical with is strangely enough care funding. I don't actually know what the Gloucester County Council's view on this is, and I guess they haven't got an official line. Let's say a person was due to receive £250,000 through their spouse's estate and effected a deed of variation and sent that money to the children. That raises the question from a care funding point of view as to whether or not that was an act of deprivation. Arguably it is, because you've decided not to receive something to which you were previously entitled to. But there might be reasons why that's the case. So it's not a clear-cut issue. It works perfectly for tax, inheritance tax. There's a little bit more of a question mark over care, but it's still at least worth looking at. And I always encourage people to say, well, now that you've been through the process of dealing with the estate, do you want to change anything about the arrangement that you've now got?